Mavka's saying Frogman disappeared into a sandstorm. What are you talking about? What are you talking about? All right, so the next thing, guys, is Stuttering John's lawsuit against Carl. If you guys, this is the Dabbleverse shit. Stuttering John, the goober from Howard Stern's show. You're like, wait, that guy's still around? Yeah, and he's not dead yet either, surprisingly. He's on the internet. You can go see him out there. But anyways, it's from the Dabbleverse, and he is suing Carl, the guy who runs Who Are These Podcasts channel, and then also Shuli Agar, the guy who runs the Shuli Network, and the Shuli Network is like, well, actually, the whole Dabbleverse is all about A-logging the shit out of Stuttering John. That was its raison d'etre, but its existence, its essence. If they were Mr. Meeseeks, that was their purpose. It's that purpose has since now kind of like blossomed into other things, and then you got like the Hackverse and all that with Melton, and then Nick apparently thinks he's a comedian now. That is what's going on there. We do have a notice of some things that have happened though. Remember last time we talked about this, Stuttering John's lawsuit was moved from New York City, from the New York City area, all the way up to Rochester, New York, where Stuttering John alleges that the DabbleCon, which is where they basically sat there and shat all over Stuttering John for a weekend, was where it happened. And as I talked about when we were reading through all the initial filings, that's where it should have been filed anyway, was all the way up in Rochester, New York. And for those of you, once again, if you guys don't know what we're talking about here, this is New York right here. Here is New York. All that. There's Long Island. And then here's New York. If your geography sucks. So anyways, New York City, way down here. Rochester, New York, where Carl lives, and this is where they did the DabbleCon, all the way up there. So that's a very long drive for Stuttering John. He's down in Florida or wherever the hell he is. But where he wanted to do it, this is, like 6.5 hours away. It's like 6.5 hours away. So this is the proper place for it. Now, what do we have? The first thing that got, and, we'll just start off with this because there's a court date being set. This was filed today at 1:00. And you can see that because it says it up here, 4/3/26. The judge in this matter has set this for a hearing in an in-person conference. I mean, Stuttering John's got to scrape up a bus ticket. But it's an in-person conference in chambers at the Hall of Justice in Rochester, New York. The failure of any parties to appear as provided herein will result in this matter being disposed of. So if Stuttering John can't scrape out enough change out of his couch, he might be fucked if he's not there. Remember, he's suing Carl and Shuli. So that's going to happen April 22nd at 10 a.m. That's a lot of hand job money. I don't know. For Stuttering John, it might be. I don't know. I don't know how much he charges for handies. He might be able to just go on the I'll jerk you off with a hand that has touched Howard Stern. And there's probably a lot of guys who would be all about that. So he actually might be able to make a lot of money really quick, given how things are. Did I say 10 a.m.? Okay, yes, 11 a.m. There you go. Now, this is the interesting thing, and we talked about this previously. Stuttering John had filed a bunch of affidavits, and I think we went through all of them. And I think you guys, if you don't remember me, every time something happened with these affidavits, they were like carbon copies of each other. Exactly, and each time Stuttering John, he did an affidavit one day, and then he was in another state the next day, and he signed another affidavit, and then he signed another affidavit in another state on a different day. And they were all like right after each other. And then people in his life, apparently family and friends, were signing affidavits, but they were literally carbon copies of things. It was very, 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 very weird. It was very weird. It's almost like, well, it wasn't like, it was. They were fucking fake. They were fucking fake. I mean, that was my conclusion, and obviously, and I think a lot of people agreed, and I think the court's kind of like, yeah, I kind of want to know what this is all about. Because here, this is a letter. Remember, chat, in New York and in the Northeast, a lot of things are done by letter as a type of briefing and filing and motion practice. So you would file on letterhead. In the Midwest, this would actually be an emotion with a caption and everything. This is a little different. Mavka says John is in Cape Coral. Oh, God. Damn. I feel bad for the people in Cape Coral. That's not good for them. I mean, shit. That's rough. That's rough for those people down there. That's rough for them. Too bad, like, instead of Cape Coral, like, move him to, like, Imalaki or something where the fucking casino. Oh, I think he'd probably like that too much, having the casino there, but isn't, like, Imalaki where it's, like, all ghetto? I think that's what my mom said about down that way. So I asked her, like, what's that town name? She's like, Imalaki. And she's like, I'm like, what's there? And she's like, oh, it's all ghetto. You don't want to go there. I'm like, okay, fair enough. Fair enough. Fair enough. Now, what's going to go on here? Why is trolling Stuttering John even a thing? Because Stuttering John's cringe and an asshole, and he, it's kind of one of those deals. He deserves to be felted. That's the thing. He deserves to be felted. So that's the issue. I can't. Yeah, he has to drag his broken wrist to Rochester. Yeah. Apparently, he was given those too aggressive of a handy, or he tried to jack off some sort of bull, and the guy jerked too hard. I don't know. I don't really know how he broke his wrist. I don't really fucking care. I'm just gonna. That's my headcanon here. That's my headcanon. So what does this letter say? What does this letter do? So this is the judge saying, I represent all the defendants. Remember, it's Carl. Remember, he's suing them individually. He's also suing them and their channel, their company. And then he's suing Shuli. And then he's also suing the Shuli Network in the above case. And he says they want to bring an in-person conference in Monroe County, which is where Rochester is, prior to the court's decision on the pending motions and cross motions. Remember, those motions haven't been addressed. All the motion to dismiss, all the motions, everything has been filed. Remember, there were like 100. There were 100 entries already on this case, and nothing's happened. The court needs to sort that all out first, and that court has to get caught up on all this. But remember, in January, there was a motion to transfer from New York County, where Manhattan is, to Monroe County was granted. So all the motions and the motions that were here, there are pending motions pursuant to various New York civil laws, and ultimately New York's anti-SLAPP law. Because remember, Stuttering John is basically claiming, he claims all kinds of economic crime or economic violations, economic torts, staking his personal image, like name, image, and likeness, more or less. And then also just they're being mean to me. Well, that's free speech, motherfucker. So there's an anti-SLAPP motion pending, a motion for a stay. There's also a motion for an expedited decision, and a motion for mandatory costs and fees. And then there's a bunch of other motions that have been filed. Stuttering John, there's also Stuttering John filed motions as well, and those were all transferred up here. So they request a conference because there are two issues that should be raised to the court. And this is, this is a big problem here. Kind of funny. The first issue is Stuttering John's attorneys may have quit. Wait, you mean to tell me that John probably didn't pay these fucking guys? No way. I'm shocked. I'm shocked that a lolcow would not fucking pay his attorneys. But the two attorneys who were on the record, Taber Benedict of the term Benedict Advisors, filed the original complaint on August 7th, 2025. And this is the weird fucking thing. They amended it immediately on August 12th. and then again on September 12th. So within a month, they amended it 3 times, and one of the amendments was for, they just fucking wasted an amendment. There's another attorney, Bennett Susser. Bennett Susser of Jardim, Meisner, Salmon, Sprague, and Susser entered his appearance after that. They believe the plaintiff's attorneys may have quit working on the case, and communication has broken down between the attorney and client. The case on the document, however, remains possibly with no one at the helm. Now, here's the problem. Even if you aren't being paid, you can't just say fuck it and leave. You have to make a motion to withdraw. Now, you could point out, attorney-client issues have arisen. We can't continue on. This is a brand new case, so you probably get a chance to withdraw. I'm sure that, you'd have to go into court and explain that. And what happens from there? Well, this sounds like for the Stuttering John side of this, it's, I told you this before, from this old-timer judge, he called it a Rule 1 violation. Or if you watch the Lincoln Lawyer, they're having trouble getting hold of a very important witness, a Mr. Green. And if he's not paying, they're going to quit. So you can't just leave. They say Tabor Benedict has disappeared. And they say attorney Tabor Benedict, who's filed every substantive document, may have abandoned this case. And he says, in November, I wrote a comprehensive letter urging him to drop this lawsuit and provided reasons for it. The guy never acknowledged or responded to the letter. The last response or communication was last year on December 16th at 10:43 a.m. And in that email, Benedict responded to an inquiry from defense counsel, meaning this guy here. Oh, who's their attorney? Daniel Savalos, this is Shuli and Carl's attorney, who this guy's actually been, once again, I'm assuming he's a very good attorney, but he's just been doing the work, which when you're looking at compared to Stuttering John's attorneys, makes him look like a rock star. I'm sure this guy's good, but once again, this is just an example of competent lawyering versus dog shit lawyering. And they say that by saying only that Mr. Benedict shall defer to Bennett, and that's the other attorney. Let off some steam, Bennett. Since then, defense counsels emailed Mr. Benedict at least 8 times with no response. In retrospect, the 100% deferral might have been a subtle message that Benedict was no longer working on this case. Yeah, but you can't just quit. You can't just quit. This is interesting, though. Information has since emerged that may explain why Benedict has stopped working on the case and is ignoring communications and notices. It appears that Mr. Benedict may have brought an action against Mr. Melendez, perhaps for unpaid attorney's fees. The image at right appears to be the caption of an arbitration case. Benedict advisors John Melendez. Now, here's the thing. Taking your client to arbitration like this is some Jew shit right there, man. Wow. Like, get some fucking money up fucking front, dude. Like, did they really take Stuttering John at his word? Oh, I'll gladly pay you tomorrow for a hamburger today. It's like, come on, man. You deserve to get fucking hosed if that's what happened. You deserve to get hosed if that's what you did. Come on. Say counsel wishes stress, however, this is an image that has been shared on social media, including at a shortcut here. I don't have any way of verifying yet, and there's no shortage of pranksters in this online universe. They say, and indeed, one commentator on the website says it looks like a photo of a Word document. Yeah, it does. It's not clear. It looks like this, and this right here is kind of the dead giveaway that this is a Word document. But we really don't know. Bella says, or the check bounce. Well, that's why you don't take check. You could take a bank check. But no, I take a money order, but I ain't taking a fucking personal check. There are like maybe a handful of people I take a personal check from, and the number of them would be on my hand, and one of those would be my mom. But I ain't taking a fucking personal check. Oh man, And no attorney there, right? Taking a fucking personal check, you need another fucking hole in your skull. So, could I get paid in gold coins? Yeah, sure. You came to me with a bunch of fucking Krugerrands, I take those as payment. As long as you can tell me they're not stolen. You come to me with Swiss gold. Like, I've had clients like give me the title to their motorcycle or tools, or guns. Now, when it comes to guns, I need proof they bought the gun, because I'm not taking some clapped out SKS that looks like it's been sitting in a septic tank, because I don't want to deal with that being stolen. But if they could bring me paperwork on a gun that they bought and show proof of that, yeah, I'll take it and hold on to that. And then I've had clients say, well, here's your money. And I'm like, well, here you go. Or, if they can't do it, it's like, all right, well, I'm taking that and, it's mine now. So there are ways you can get paid. Could you pay me in fairy dust? No. When cash is offered, the price goes down for just about everything. Well, yeah, of course, because cash, IRS, never heard of her. So can't spell IRS with cash. So yes, that's a great thing. However, based on my own experience with this, the caption in the first part of the case appear legitimate. Of course, the document would need to be authenticated by either Benedict or Stuttering John. And if it's true that Mr. Benedict is now embroiled in a fee dispute, or if there's just been a breakdown of communication, then yes, Benedict cannot simply quit working. In addition to his ethical obligations, he has a responsibility to this court and opposing counsel. You do. You just can't stop work if you filed every document. By contrast, his co-counsel filed his own entry of appearance, and that's it, nothing else. And that's important because the other attorney filed everything. The complaint, amended complaint, the opposition, the cross motions, and the affidavits and exhibits. All of these are subject to the anti-SLAPP and other sanctions. And we're going to get to other sanctions in a second. And this is important. Benedict is still subject to the court's sanctioning jurisdiction. If you just quit, the court can sanction you. The court can refer you to the bar. It can make you pay a fine. It can sanction you, especially because some of these affidavits are like fucking bogus. And if you violate your rules of candor to the court can sanction you for that and punish you. You offer payment in Iranian oil? I think Supreme Court would frown upon that one. Also, conflict diamonds, they would probably frown on that one too. So, they point out it's well set under the rules of professional conduct that an attorney may not unilaterally cease representation due to a fee dispute or other disagreement with a client. Yes. And here's the thing. If permission for withdrawal is needed or is required, a lawyer shall not withdraw without permission. You can't just quit. You have to ask for permission to withdraw. And it further mandates, in order to do so by a tribunal, a lawyer shall continue representation, notwithstanding good cause for terminating the representation. Now, there might be times where you have to continue. Like if this is the day before trial, you're not quitting. You're going to have to handle it. But this early on, they're probably going to have the hearing on the motions. And then at that point, Benedict would probably be allowed to withdraw. And then they talk about the model rule. And the model rule is promoted and promulgated by the American Bar Association. So we have the rules of professional conduct, and every state basically copies the model rules proposed by the American Bar Association. The model rules contain the same directive requiring continued representation where the court so orders. And say, even if non-payment of fees might constitute grounds to seek withdrawal, and it probably is, in their fee agreements and their engagement agreements, it probably includes if I can quit if you don't pay. And that's acknowledged in writing that if you don't pay, I can quit. So none of this is going to be a shock to John. I'm sure he's going to be like, whoa, I don't know, or whatever, however he does it. Now, that provision permits merely a motion to withdraw. It does not authorize abandonment of the attorney's responsibilities to the client in the case. They say once an attorney has appeared in a matter, a fee dispute does not relieve your obligation to continue litigating until you're allowed to leave. Now, what else has happened, though? Well, Stuttering John himself has suggested there might be some sort of problem. No, I will not do that for heroin chat. They point out, although the other attorney has communicated intermittently, several weeks ago, Susser reached out for the purposes related to the civil rules or civil law. I forget. Hey, yeah. Anyways, after discussion, Susser said he would get back in touch soon. 2 weeks later, he called to say he had been busy and that he'd be in touch soon. That was 2 to 3 weeks ago. Defense counsel's heard nothing since. So it's been a month really since they had any communication with the other attorney. I was going to say, it's my understanding John never pays. Yeah, I mean, that's always been my understanding. He doesn't pay on shit. Like, doesn't he get evicted too on things? Isn't that part of his issue? Jelly Jerome says, let's say you really want to get off a case due to a lack of payment. What's the good tactic? There's not really a tactic. You just file with the court and say, Your Honor, there's a breakdown in the attorney-client relationship. There has been a failure by the client to fulfill their obligations under an agreement. You don't have to say specifically this motherfucker won't pay. You church it up and you use the reasons listed and craft a way around it because you don't hurt the client. You still have a duty to your client not to hurt them in that. And here is, for example, we'll go right here to the New York rules. Rule 1.16. Now, if you're talking about this, we're not worried about this, about the, conflicts here, the issues about supporting it. We want to get down to the lawyer shall withdraw. Okay, well, what shall withdraw? Well, when you know representation is violating the rules, when your mental condition materially impairs your ability to represent a client, that's another one. You're like, well, what does that mean? Well, like, if you know you can't handle it, you shouldn't take it. Like, for example, if you're in the middle of dealing with cancer and you know you're going to be laid up, you shouldn't be taking representations. But we got to get down to the may withdrawals. Because that's where we're talking about the discretionary withdrawals, when you're seeking permission to withdraw. So you may withdraw from representing when it can be accomplished without materially adverse effects on the interest of the client. The client persists in a course of action involving the lawyer's services that you believe are fraudulent, that he's used your services to perpetrate a fraud. The client insists upon taking action which you have a fundamental disagreement with. The client deliberately disregards an agreement or obligation of the lawyer as to fees. And then really, here's the stuff you can do here. The client fails to cooperate in the representation or otherwise renders the representation unreasonably difficult for the lawyer to carry out an employment efficiently. This is something you would really try to focus on here. You could say 5 because he's not paying, but you'd really try to focus more on this here. I would, just because you don't want to make him look bad. You want to make him look bad. Yes, John is not the sharpest spear in the quiver. Well, he'd be the arrow in the quiver. You wouldn't put spears in the quiver. Unless that was the joke. They say the lawyer's inability to work with co-counsel. If, he hires not like it's in your own firm, but he hires a separate attorney and he's in a different firm and you guys don't get along. You're like, fuck it, I got to quit. Your mental or physical condition. So let's say you're representing somebody and you get cancer or you suffer a mental breakdown. You're like, look, Judge, I got to get out. Court will let you get out generally. Stuttering John freely assents to the termination. There's a lot of things you can do here, but those are the big things, what they're going to ask to get out. And where is, that's not right. Where is, uh-oh, chat, I think I lost something. Oh, there it is. God, I lose the tabs. What about a stroke? A stroke would also be a similar thing. Yes, severe medical emergency. I thought Artie was a cokehead. He certainly lost his nose over it. Yeah. They say, meanwhile, the plaintiff has suggested there's and what ultimately, Jelly Jerome, you can't constructively get him to fire you. That could lead to bar issues. So no, you just be like, look, he hasn't paid. That's it. That's all you got to do. So Stuttering John himself suggested there's a serious breakdown. On or about March 14th, Stuttering John made public comments that he's not aware of what his lawyers are doing, and he only gets his information from people other than his lawyers. The problem is Stuttering John's a retard, so who knows? And then, yes, there is Stuttering John claims attorney tried to settle with Shuli and Carl behind his back. Well, that alone already, and this is here, if he makes this claim, there's already a massive issue. And he says that. He's like, I think one of my lawyers tried to say, settle, I think. That's what people tell me. I don't really follow it. Then how the fuck do you know what's going on? How do you know what's going on? And it says, plaintiff suggests communication with the lawyers John's lawyers is broken down to the degree attorneys are trying to settle without his knowledge and authority without informing him of developments of the case, which is another violation of the rules. And this is the attorney now saying, well, I think it unlikely that Mr. Susser would attempt to settle the case without his client's authority. The plaintiff's public statements raise concerns that if defense counsel relied upon Susser's offers to settle, they would be without the plaintiff's authority, meaning they're saying, we don't think he would do it, but if he did, we have reason, like anything he'd say, we couldn't trust. So, yes, we need to come into court and the judge needs to look at everybody and say, what the fuck is going on? And yes, this is a great time Stuttering John to say, are you just a retard or are you saying things that really happen? They say no attorney responded to this draft letter a week ago. Oof. And they say, as further evidence, there may no one be working on this. On Sunday at 2:50 p.m., the undersigned emailed a draft of this letter to both Susser and Benedict as a good faith effort, asking them to meet and confer and to avoid having to file the letter. Meaning, he's like, look, guys, if you don't talk to me, I got to file this because I don't know who the fuck's in charge. But if you meet with me, obviously I can't file it because at that point I've talked to you. So just get in touch with me, please. And it says, given the professional responsibility implications of the letter, I assume Benedict or Susser would immediately respond to deny or at least address the issues. For example, if the image on the arbitration case is false, if Benedict is not bringing that, I would expect Benedict to immediately protest and insist he's still in the case. Also, if it's not true that Susser had a breakdown in communication, one would expect Susser to immediately send an email saying the concerns are misplaced and he's still on the case. That's not what happened. Nobody responded or even acknowledged receipt of the letter. They completely ignored it, which is a sign that they kind of bailed, Bo Beats Black Sheep says, I predict an elephant roar in your near future. Is that some gay thing Stuttering John tries to do or something? I don't know. Anyway, there's Stuttering John looking pretty rough. They say the second potential issue, and this is that one's a big one for the attorneys. That's an issue of they're going to have to answer for what the fuck's going on. But this is the second, there's two issues that they could be sanctioned on. And then Stuttering John could be facing sanctions himself on this issue because he's signing these documents. If you're signing documents, your ass is attached to them. So if your client signs something, yes, as an attorney, you're liable for it because you're filing it and signing it. But if your client signs it, that's their ass on the line too. That's their ass on the line as well. Now, here is the second thing. He says, I have recently learned that one of plaintiff's witnesses may have submitted a knowingly false affidavit to the court in opposition for the motion to dismiss. They say in opposition to the pending motion, plaintiff filed no less than 5 affidavits. One of the affidavits from Mr. John Melendez. 4 from other individuals. And remember, guys, they're all identical to each other. They're literally identical. All the things are identical. We went through those. Remember, they are literally just copy and paste names. Not just similar, identical. Yeah. One affidavit's from an individual, JM, who also goes by the name Vegas Beer Sales Jerry. I learned after the plaintiff submitted these identical affidavits that JM, or Vegas Beer Sales, admitted to on Melendez's show to Stuttering John, he simply signed whatever affidavit the lawyer sent to him, no matter what it said. Well, I mean, there you go. I mean, I'm not going to go back through and watch fucking Stuttering John. I don't think any of us should be forced to do that. So we're not going to click on any of this shit. Thank God it's not live. So thank you to Attorney Savalos for not making us suffer through that. And they point out and this is the thing I was confused too. It's unclear why these were submitted because the facts in it are largely inadmissible and irrelevant. I know we went through that and we're like, what the fuck were these points? I don't know. You mean you don't know Stuttering John's ever entertaining hand horn bits? No. I mean, like the only horn thing I want to see him handle is like a flash suppressing cone on the front of an M1 Garand as he puts it in his mouth. Then I'll watch him play that. But otherwise, no, I don't really care for Stuttering John. I watch clips sometimes. Oh. Chet Manley says, turns out the rule about not getting involved with the cows includes being their lawyer. That's not true. You can be a lawyer representing cows, but the biggest problem is cows pick attorneys who are just like them. Or you see people like down in Texas, the Antifa guys who got convicted for their terrorism case. You picked activists or people who are like fellow travelers in your cause. And you guys are both down with the struggle. That's not what you need as an attorney. An attorney needs to be a counterweight. You know, it shouldn't be somebody who's like, oh my God, he's my bro. It should be somebody who's not afraid to push back. You don't necessarily see eye to eye on everything. There's got to be a little difference because if you guys are completely congruent, you can't see through that. But if you're staggered, okay, we can see through this a little bit. You need a little bit of, you don't pick someone who's like you. That doesn't mean you go out and pick, like, I would go out and pick some, like, raving Trotskyite, but I'd pick somebody maybe a little more mellow in terms of how they view things than me, because that helps give you a little bit of a balance. So, you got to check. Craig says, were you a Howard Stern fan? I forget if he was syndicated in range of Ohio. He was. But no, I was an O&A. I listened to O&A. I fuck Howard Stern. I Googled myself. No, fucking Howard Stern's gay. He was gay! I just thought he was fucking retarded. Like, no, Opie and Anthony was good enough. So. They say in the video in the screen capture above, an audience member asked Jerry why his affidavit's identical to the others. Melendez certainly does not appear surprised. Indeed, he tosses a question directly to Jerry to answer it. Do we really need the exclamation point on that? I mean, yes, there was also Ron and Fez, but yes, homeless shopping spree, sex for Sam, all that stuff. Jerry's response is credible too, given that the other affidavits are identical to each other. I was gonna say, especially like back when I was a kid, like when I worked my summer jobs, though, like, you're working as summer help, so like whoever's driving like the work trucks or whatever, they're listening to like 100.7 WMMS, so we hear Chad Zumach. So it's like all this shit kind of comes back circular for me in life. So, but anyway, says Jerry's response is credible too, given that other affidavits are identical to each other. And here's the thing, chat, when it comes to like Jerry's statements, nobody would say that unless it were true. Why would you say that you just signed an affidavit without reading it, and that, you wouldn't say that thing unless it were true? You wouldn't say that thing unless it were true. So there's going to be a lot of credence to that he's telling the truth. Coast to Coast was peak. Yes, it was. And they say if the affidavits are indeed false, not the words of the affiants, then I believe I am duty bound to bring this attention to the court before the court considers them with the plaintiff's opposition. That's true. If you have reason to believe these are fraudulent, you have to raise it. Now remember, Stuttering John's, his ass is grass. This guy Jerry could face sanctions, and the attorneys could face sanctions. A lot of people could get hemmed up in this. Now, I understand on the, when the dabblers are going to be like, Stuttering John's going to prison, yay! And he's going to get fucked to death by some bull. No. No, that's not going to happen. Like, you're not going to get perjuries, nothing like that. But are these people going to get, like, butt fucked by the judge? Probably. Probably, and it'll be hilarious. It'll be hilarious. I was like, kind of like my Tukey thing. Yay! It's not going to happen here. So they say the notice of an available dates for in-person court dates. And they say, look, Your Honor, we request an in-person conference. Should the court wish to consolidate this date with oral argument and evidentiary hearings on the pending motion, meaning this motion right here, the defendants can be ready for that as well. Defense counsel submits his upcoming unavailable dates, and he's like, look, Your Honor, any dates but these I can be ready for, which is, impressive. He's making his calendar flexible, which is good because that, and we got the date got set April 22nd. And it comes right in between those. So, respectfully submitted, Daniel Savalos Esquire. Just kicking ass right there. Kicking ass. So, yeah. Mm-hmm. Jerome says, anybody remember lady died from ONA? I remember, like H. Cup Jane, Pat from Minaki. I think they had a porn star come in and blow him. I forget which one it was. Pat from Minaki. There were a bunch of people. I remember. It was a good show. Yeah, but John sounds like John's fucked. Sounds like John is fucked. So he better gonna have to chug a Michelob before he goes into court because he's not gonna have a good day. So that's where we are with Stuttering John. The shit winds are a brewing. The shit winds are a blowing, chat. Not brewing. The shit winds are a blowing. And yeah, Stuttering John is going to get, good and fucked.